Greetings to all from Pretoria in South Africa. Before I make my presentation, I would like to thank the organizers of the conference for the opportunity to share a few thoughts with you on the legal challenges related to the establishment of human settlements in outer space, and then specifically the application of the current international human rights instruments in these settlements. As such, the aim of the presentation is to highlight some human rights challenges when living in outer space and to examine the role that the doctrine of effective control may have in applying human rights instruments in outer space settlements. In 2001, the late Professor Stephen Hawking predicted that humankind would have to move into outer space for the sake of its own survival. Recent international developments in the area of the military and commercial exploitation of outer space show that this prediction is more than mere science fiction. In fact, there is a reasonable expectation that the military and commercial exploitation of outer space will only increase in future. In contrast with the early years of spaceflight that were dominated by the political priorities and military concerns of the two superpowers, the USA and the then USSR, a new space era has dawned, where not only states are involved in outer space activities, but also private companies have emerged as serious actors in the space arena. The importance of outer space to both states and private companies may be illustrated by two recent examples. The first quite serious, the second a bit more light-hearted. In the first instance, recent state practice suggests that states increasingly view outer space as a separate military domain. After the establishment of the United States Space Force in 2019, a number of states, including France, Japan, and the UK, have followed suit by creating or planning to create space commands or space forces in their existing military architecture. In addition, NATO adopted its space policy in 2019 and recognized space as a new operational domain alongside air, land, sea, and cyberspace. Despite states' continued assurances that outer space will be used for peaceful purposes, one has to take note of Theodore Goodman's cautionary observation that the integration of space assets into national and economic systems and military defenses makes space an attractive battleground. The second example is perhaps a bit more light-hearted. Also in 2019, the well-known French champagne producer MUM International, in collaboration with the space design agency Spade, developed a champagne bottle and glass that will allow for the pouring and drinking of champagne in zero gravity. It is clear from the media report that this development is aimed specifically at the future commercial utilization of outer space in the form of space tourism. As part of these developments, the establishment of permanent settlements in outer space is receiving the serious consideration of both states and private companies. There is currently renewed interest in lunar exploration and plans to establish human settlements on the Moon and eventually on Mars in the near future. Most notably in this regard is NASA's Artemis program, which aims to establish long-term human presence on the Moon as a gateway to eventually also settle on Mars. In addition, private companies such as SpaceX and Blue Origin declared plans to establish human settlements on the Moon and or Mars. The current discourse in the international political and legal arena on the establishment of human settlements in outer space within the near future is in many respects simply, for lack of a better word, mind-boggling to the average person. Unbelief as to the possible realization of such a venture primarily relate to the technical issues involved in transporting the participants to and sustaining them on the celestial body where the settlement is to be established. Some scientists are therefore doubtful that the aim by private enterprise to establish a human settlement on specifically Mars would be realized soon. In fact, Neil Armstrong, the first man to set foot on the Moon, believed that the problems associated with deep space travel and the eventual establishment of a human settlement on Mars should be conquered in measured, incremental distances by further exploring the Earth-Moon system. It could, however, be accepted that, in view of rapid technological advancements, it would be possible to establish a community in outer space within the not-too-distant future, if not on Mars, then on the Moon, which would be less of a scientific and technical challenge. From a legal perspective, however, the establishment of a human settlement in outer space presents equally challenging questions with regard to the legal nature of the settlement and the regulation of the various relationships between the participants in the planned project. Consequently, the question arises whether the current regime of outer space law in general and international human rights law in particular will be able to regulate these developments sufficiently. Discussions relating to the relationship between human rights law and outer space law have until now largely focused on the influence of outer space activities on the human rights of individuals on planet Earth. However, the possible establishment of a human settlement in outer space brings to the fore the application and enforcement of human rights not only on planet Earth, but also in outer space itself. Already in 1968, at a conference organized by the American Institute of Aeronautics and Astronautics, Carl Crystal delivered a paper on human rights in outer space and observed in his introductory remarks that while human rights agreements have generally been identified as being Earth-orientated, there is no fundamental reason for not recognizing their applicability on the space environment. The question arises whether, under the current circumstances, this is a valid statement that may be accepted unequivocally. It is right that technology relating to the exploitation of and control over outer space has since developed immensely, and that not only states, but also the individual as a natural person in outer space and as part of a settlement in outer space stands at the center of it all. The idea that international human rights should apply to persons while traveling or living in outer space seems to be suggested by the Outer Space Treaty itself in Article 3, which determines that states parties shall carry out their space activities in accordance with international law, thereby confirming the applicability of international human rights law to outer space. The relevance of human rights in outer space is further underscored by the Space Shuttle Endeavour, launched by the United States of America on 14 November 2008, which docked at the International Space Station the following day with a copy of the Universal Declaration of Human Rights on board. This symbolic act accentuated the importance of human rights in the space environment, but also highlighted the unique and difficult legal challenges related to the application of international human rights instruments to outer space exploration and travel, to which there are not yet generally internationally agreed upon solutions. While legal experts wrestle with issues relating to the establishment and functioning of settlements in outer space, technology advances relentlessly. On 9 July 2014, BBC Future reported that the second International Extraterrestrial Liberty Conference, organized by Charles Cockle, an astrobiologist at the University of Edinburgh, had discussed the drafting of a constitution for an outer space settlement on Mars. Cockle believes that the proposed constitution should contain a Bill of Rights that takes into account the very special circumstances under which such a settlement would live and function. It is argued that the proposed constitution should, for example, make provision for the right to leave the settlement and the right to have oxygen supplied to one at all times. The practical issues related to the realization of these rights are immense. Delegates at the conference, for example, agreed that the right to leave should be included in the constitution, but how to practically leave a settlement on a planet without breathable air is not clear. Another practical problem that was raised at the conference concerns the governing of the settlement. What is to be done if the governing mechanisms of the settlement fail and brutal dictatorship emerges? Whether and how any proposed constitution would be able to deal effectively with a situation is not clear. In this regard, Charles Cockle warns that the unique environmental conditions in outer space will necessitate much stricter rules than those on Earth to prevent tyranny. Seeing that states, private enterprises, and individuals as citizens of the states and as clients of the private companies will be involved in a space settlement, the nature of the various instruments containing the rules that regulate the wide-ranging legal relationships will also differ materially and will probably range from treaties to legislation to contracts to codes of conduct and even something akin to a constitution. An example of such a constitution is the one adopted in 2017 by the Space Kingdom of Asgardia. Igor Azerbai, the founder of the Aerospace International Research Center, proposed the establishment of Asgardia in 2016. The Asgardians describe themselves as a space nation that aims to ensure the peaceful use of space, to protect the Earth from space hazards, and to create a demilitarized and free scientific base of knowledge in space. Its long-term objectives include setting up habitable platforms in space and building settlements on the moon. Currently, Asgardia has more than 1 million so-called citizens from all over the globe. In 2017, Asgardia launched a satellite, Asgardia 1, and declared sovereignty over the space occupied by it. Although one may argue that documents such as this should be viewed lightheartedly as a utopian idea by its authors without any clear legal value, it is nevertheless suggested that it at least constitutes an example of the kind of thinking of a substantial number of people regarding the uses of outer space. A vast number of vexing issues, which primarily relate to the application and enforcement of international human rights within the outer space settlement itself, can be identified. I will therefore only focus on a few of these issues to illustrate the extent of the legal uncertainties, which in turn may have a bearing on the application of human rights in outer space. For the sake of legal certainty, it is clear that the legal status and role of the participating states, private persons, and entities should beforehand be determined and described. It is, for example, not clear whether participating persons would have the status of astronauts, and if terms in the space treaty such as astronaut, personnel of a spacecraft, and envoys of mankind would consequently apply to them all. Determining the legal content of the different relationships in a space settlement is in itself a daunting task, as it would require the participation of all parties involved in the project and the creation of a new legal regime based on the various domestic legal systems applicable to at least the prospective participants, as well as relevant international rules and norms governing activities in outer space. Even before deciding on the constitutional nature of the settlement, clarity needs to be obtained as to what would constitute a settlement in outer space. Literature described these so-called colonies as planetary settlements and artificial habitats, depending on whether they are established on a planetary body like Mars or on an artificially created habitat. As far as the legal nature of the settlement is concerned, would it, for example, be a kind of nation-state, endowed with a kind of sovereignty and governed by a kind of government in terms of a kind of constitution? The term kind is used intentionally to emphasize that the situation at hand could not be equated with the current situation on planet Earth, where a clear structural division between the legislature, executive and judiciary is part and parcel of most democratic nation-states, and where the actions of the state and its inhabitants are regulated by a constitution and/or legislation. This issue is clearly linked to the question whether the inhabitants would retain their political rights in terms of the constitution of their states of origin, and in principle be allowed to participate in the political processes, for example, elections of those states. In this regard, it is interesting to note that the constitution of the Space Kingdom of Asgardia explicitly determines that no political parties would be allowed in Asgardia, but that every Asgardian can freely participate in the political life on Earth. The difficulties associated with the practical exercise of these rights on a celestial body, separated in time by many months and by distances of millions of kilometers from planet Earth, is obvious. The ultimate question to be decided upon by the international community is whether a settlement should be allowed to develop into an independent nation-state. Currently, diverse opinion exists on the nature of the envisaged space settlement. Suggestions in this regard vary from a federal model to having a private organization as governing body, while the Asgardian constitution declares the proposed state of Asgardia to be a kingdom with a head of nation. One could argue that the selected rights applicable in an outer space settlement should be formulated in detail to try to limit unnecessary problems associated with the interpretation of human rights. Conversely, as a result of the particular circumstances surrounding outer space, coupled with unforeseen situations that may arise, a too detailed formulation of these rights may actually create even more difficulties. A further closely related question concerns the extent to which the limitation of these rights would be allowed. When it comes to the interpretation and application of human rights, conflict between individual settlers mutually and between settlers and the governing body is a certainty. It is self-evident that due to the unique nature of the outer space environment, some of the rights of the inhabitants will have to be curtailed. For example, the right to procreate would in all probability need to be seriously limited to prevent an undesirable growth in the settlement's population, which might eventually jeopardize the whole of the settlement's continued existence. This inevitably also raises the question whether female inhabitants would have the right to get an abortion. Furthermore, would it be possible to realize the right to general medical services to the inhabitants of the settlement on the same level as their earthly counterparts, or should they beforehand accept that rights such as these would inevitably be curtailed? However, the yardstick that should be used to decide on the extent of the limitation of a particular human right is not clear. What may be reasonable, rational, and justifiable under earthly circumstances may not be so in outer space and vice versa. One could expect a wide variety of human rights-related conflicts to ensue, taking into account the possible diverse composition of the settlement with regard to nationality, language, culture, and religion. In this regard, it is again interesting to note that the Asgardian constitution prohibits political parties in Asgardia itself, but allows religious practices in Asgardia. The utopian ideals of Asgardia as reflected in its supreme values contained in Article 4 include non-legal concepts, such as the unity of space humanity, community and mutual support, human happiness, love, morality, and harmonious existence. Whether these values could be effectively realized, taking into account the conflict-creating potential of political and religious differences inherent in human nature, is highly doubtful. One could probably argue that the right to life contained in international human rights instruments should be interpreted to automatically include the rights to oxygen, food, and water. The realization of these rights may, however, not be without problems. It would probably be impossible to carry the necessary oxygen, food, and water on the spacecraft into outer space for a prolonged stay on a celestial body. According to space scientists, only a spacecraft with a payload of no more than 1 ton can safely be landed on Mars's surface due to its atmospheric conditions. Structures to provide these necessities would need to be erected as soon as possible after arrival. The current International Space Station to a certain extent provides an example of living and functioning in outer space, but the sheer scale of a full-blown settlement requires much more extensive infrastructure. It is suggested that before venturing into outer space to establish a permanent settlement, clarity should exist with regard to the specific life-sustaining rights the members of the settlement would be able to claim. Apart from the celestial body itself, or a specific area of it, to whom would the structures erected on such a body belong? In terms of Article 8 of the Outer Space Treaty, objects landed or constructed on a celestial body remain the property of the state party on whose registry the object is included. The position with regard to private installations on celestial bodies is, however, not so clear. Would private individuals, for example, be allowed to own a dwelling built on a celestial body for themselves by themselves? Currently, one of the most serious problems concerning the exploitation of outer space is the issue of space debris, as it has a direct bearing on the right to a clean, healthy, and safe environment of the envisioned human settlement. At present, the mitigation of space debris is a matter of voluntary compliance by states with the United Nations Space Debris Mitigation Guidelines. The issue of space debris is not mentioned in any of the space treaties, and the most environmentally relevant article in the Outer Space Treaty is Article 9, which obliges states in very general and rather vague terms to avoid the harmful contamination of outer space, the moon, and celestial bodies. The International Space Station, as the only current example of a habitat in outer space, albeit on a limited scale, has not only contributed to the creation of space debris, but has also been affected by debris created by other space activities. In March 2021, a pallet of batteries weighing 3 tons was released from the ISS, becoming one of the largest pieces of space junk ever to be dropped from the station. The seriousness of the space debris problem was highlighted again by recent emergency repairs that had to be done to the International Space Station after being hit by a piece of space debris resulting in a 2-millimeter hole through which the oxygen inside the space station leaked. In March this year, it was reported that a large piece of space junk hit the far side of the moon at a speed of 9,300 kilometers per hour. At the time, it was debated whether the debris originated from a Chinese rocket or from that of SpaceX. Apart from the space debris created by states and private companies' space activities, private enterprises have deliberately launched objects which can only be described as junk into space, the one being a huge rotating glass disco ball and the other a Tesla sports car. If interplanetary travel becomes a regular feature of human life, space debris will inevitably increase dramatically in volume. It is estimated that the limited exploration of the moon by the United States of America has generated space debris weighing in excess of 180,000 kilograms, consisting of more than 100 man-made objects. It has also been calculated that there are already more than 7,000 kilograms of human-made objects on the surface of Mars, consisting of discarded hardware, inactive spacecraft, and crashed spacecraft, as the remains of more than 50 years of robotic missions. Although scientists are currently testing technology to remove debris from space, it is still uncertain how radiation of persons on board a spacecraft would be prevented and how any radioactive waste would be disposed of in outer space. These few examples are only an indication of the nature of the legal issues facing the establishment of a proper functioning settlement in outer space, and by no means present an exhaustive list. They nevertheless raise the important question as to what extent should or could the current international instruments on the use and exploitation of outer space be used as the basis for the development of human rights instruments specifically designed for prolonged traveling and residing in outer space. It is submitted that even before deciding on the content of such instruments, one should answer the very basic question as to the extraterritorial applicability of current international human rights instruments in outer space. I would now just very briefly deal with the extraterritorial application of human rights instruments on planet Earth before turning to the extraterritorial application of these instruments in outer space. Generally, states are only bound by those international agreements that have been signed and ratified by them. However, although a state may not have signed and ratified an international human rights instrument, it may still be bound by specific obligations in that instrument where the obligation in question can be allocated the status of an obligation erga omnes, or where a human right has attained the status of jus cogens. Article 1.5 of the Vienna Declaration and Programme of Action describes the nature of human rights and the duty of the international community and individual states towards their realization. The keywords here are globally and universal. The term global seems to be limited geographically to describe planet Earth, the globe, and it is suggested that to include outer space within its ambit would be to overextend its literal meaning. The term universal generally denotes that human rights are universal because everyone is born with and possesses the same rights regardless of where they live, their gender or race, or their religious, cultural, or ethnic background. In this sense, the term universal should be understood to reflect the personal character of human rights as rights accruing to individuals wherever they may find themselves. However, geographically speaking, the term universal, according to its literal meaning, might be used to denote the entire universe, planet Earth, and outer space, and need not carry only the limited meaning associated with the term global. The basis of all human rights is the protection of the dignity of the human being. The dignity of the human being is an inherent quality of being human and is not bestowed upon people by international human rights instruments. Article 1 of the Universal Declaration of Human Rights confirms that all human beings are born free and equal in dignity in rights. In this sense, human rights are inherently part and parcel of the person of the individual, irrespective of time, place, and circumstance. To determine what exactly the territorial element linked to the application of international instruments entails, one also has to consider the relevant provisions of the human rights treaties themselves. However, the wording or lack thereof of international instruments on their territorial application creates legal uncertainty. While some instruments refer to both territory and jurisdiction, others only refer to jurisdiction without mentioning territory, and some do not contain any of these terms. Some guidance on the extraterritorial application of human rights treaties on Earth may be found in the opinions and decisions of international judicial organs. The European Court of Human Rights has mainly linked the jurisdiction of a state to its territory and only acknowledged the territorial extraterritorial application of human rights under exceptional circumstances on a case-by-case basis. Conversely, an analysis of the International Court of Justice's jurisprudence shows that the court seems to follow the approach that the extraterritorial application of human rights instruments must be ensured. It furthermore seems clear that the state's sovereignty over a particular territory is not viewed as a prerequisite for the extraterritorial application of the international human rights instruments to which that state is a party. For example, in the Namibian advisory opinion, the court explicitly stated physical control of a territory and not sovereignty or legitimacy of title is the basis of state liability for acts affecting other states. It would thus seem that it is a valid conclusion to draw from the court's observations that the title of a state over a particular territory is not a prerequisite for the extraterritorial application of human rights law, but that the state's physical control over the said territory is sufficient. The United Nations Human Rights Committee, in its General Comment number 31 on the nature of the general legal obligation imposed on states parties to the International Covenant on Civil and Political Rights, declared that states parties must respect and ensure the rights laid down in the covenant to anyone within the power or effective control of the state party, even if not situated within the territory of the state party. It must, however, be kept in mind that these judicial decisions should not be interpreted to create any generally applicable norm concerning the extraterritorial application of international human rights instruments. The said decisions should be limited to the international instrument and the circumstances before the particular judicial organ, and should thus be treated only as indicative of a developing trend in international law. I now turn to the extraterritorial application of human rights instruments in outer space. The international legal position concerning the rights and obligations of states on planet Earth and in outer space is vastly different. The specific question here is whether states in their exploration of outer space are, as in their activities on planet Earth, under the obligation to respect, promote, and enforce international human rights in terms of the various international human rights instruments. The issue thus boils down to the question whether the various international human rights instruments are also extraterritorially applicable in outer space. At the outset, it must be remembered that international human rights instruments are essentially agreements between states, although the beneficiaries in these instances are mostly individual persons. Currently, despite claims such as that of the Space Kingdom of Asgardia, the nation-state is a phenomenon limited to planet Earth. This is because of Article 2 of the Outer Space Treaty, which determines that outer space cannot be appropriated by claim of sovereignty, means of use or occupation, or by any other means. It must therefore be accepted that for the immediate future at least, no earthly entity will be able to establish itself in outer space as a nation-state in the formal sense of the word. Even those states that did not sign and ratify the Outer Space Treaty are bound by this provision, as it could be argued that it have already attained the status of customary international law. The question has been posed whether a group of people living on a celestial body, such as the Moon or Mars, could be viewed as an extension of the sending state. Mukesh Bhatt suggests in this regard that the Outer Space Treaty's prohibition with regard to sovereign national appropriation in outer space may be circumvented by arguing that the Outer Space Treaties do not prohibit sovereign states to exist in outer space, as long as these settlements do not derive from Earth-based jurisdictions. Such an entity would thus need to declare itself autonomous and independent from its originating jurisdiction on Earth. This approach, however, does not provide the full and final answer to the question on the extraterritorial application of human rights instruments in outer space. As has been indicated earlier, there seems to be a developing tendency to accept the extraterritorial application of international human rights instruments. In fact, General Comment 31, referred to earlier, explicitly determines that states must ensure the protection of the human rights of those persons under its effective control, even if they do not find themselves on the sovereign territory of the particular state. The application of the control set test in outer space, however, gives rise to specific problems. Firstly, as has been indicated, the Outer Space Treaty not only prohibits the establishment of sovereignty over any celestial body, but also explicitly provides that no state may occupy any celestial body. The occupation referred to must of necessity be permanent occupation, since temporary occupation of a celestial body could form an inherent part of the mere exploration of outer space. It must also be pointed out that the Outer Space Treaty does not specifically employ the concept of effective control, but rather makes use of the term supervision in the sense that it requires a launching state to exercise continuous supervision over the particular space activities. Whether the term supervision should be construed to imply effective control, and whether continuous supervision is supposed to also include control over any settlement that might be established by the launching state as part of the particular outer space activities, is unclear. Secondly, the Outer Space Treaty is only binding on states. However, states and private institutions may also be joint partners in an outer space venture. The question immediately arises as to the binding nature of specifically international human rights instruments to the activities of private enterprises, the normal rule being that such instruments only apply directly to states as the primary subjects in international law. A situation where a private enterprise will conduct its activities in outer space without any form of involvement of the state would probably never occur, since certain legal requirements set by the state must be fulfilled before a private enterprise would be allowed to perform its planned activities in outer space. In that sense, the link between the state and the private enterprise could form the basis for the argument that the actions of the private entity could be imputed to the state, thereby bringing it under the scope of international human rights treaties to which the state may be a party. The Outer Space Treaty explicitly determines in Article 6 that states parties have international responsibility for the non-governmental entities in space and requires that these activities be authorized and continuously supervised by the state. This provision seems to provide a basis for arguing that it is required from both the participating state and private entity to jointly exercise effective control over the settlement through authorization and continuing supervision by the state on the one hand, and responsibility for compliance with the Outer Space Treaty by both the state and private entity on the other hand. Authorization, supervision, and responsibility all point to effective control. This point is further enhanced by Article 7 of the treaty, which provides that a state party on whose registry an object launched into outer space is carried shall retain jurisdiction and control over such object and over any personnel thereof while in outer space or on a celestial body. Thirdly, a specific outer space project often concerns by way of agreement the simultaneous involvement of a number of states and private entities. This fragmentation of the rights and obligations between the various parties to the agreement could create a lot of uncertainty as to who exercises control over what and in terms of which legal regime. The circumstances under which inhabitants of settlements in outer space which have to live differ profoundly from those on planet Earth and would need to be reflected in the constitutional arrangements applicable to them. Mukesh Bhatt describes the typical circumstances a settlement in outer space have to contend with by referring to the dangerous nature of life in outer space, where people from different cultural backgrounds with different beliefs and values will demand their equal share of common necessities, such as food, water, and air, in a place where available resources will be limited. In conclusion, it seems that the international human rights instruments drafted on and for planet Earth may find extraterritorial application in outer space, albeit in a qualified sense, because of the particular circumstances and living conditions in outer space. The reason for this is that the establishment of sovereignty by a state or states over the celestial body on which the settlement is founded is not a prerequisite for the application of human rights treaties that we initially drafted for application on planet Earth only. Effective control over the settlement seems to be sufficient. The international aspects inherent in the exploitation of outer space, as illustrated by the examples mentioned, necessitate that the current outer space legal regime be reviewed as soon as possible and thereafter constantly complemented by new rules to regulate the legal implications of scientific developments related to outer space. It would probably be easier to reach some consensus between all role players if the legal rules agreed upon takes the form of soft law, but hard law would ultimately be necessary to achieve legal certainty and accountability. The international context of the outer space legal regime requires that a credible international organization with the necessary capacity and representative of the vast majority of states be the driving force behind the adoption of a human rights framework tailor-made for outer space circumstances. The United Nations, and then specifically its Committee on the Peaceful Uses of Outer Space, seems to be the only body that can successfully facilitate such a mammoth task within the near future. As Colin B. Picker notes, technology operates as an invisible hand on international law, guiding and shaping its development. It is therefore imperative that an international dialogue on the protection of human rights in space be facilitated under the auspices of the UN COPUOS as soon as possible to address the legal challenges highlighted in this presentation. Thank you.